Antitrust refers to a set of laws and regulations designed to promote fair competition in the marketplace. These laws aim to prevent businesses from engaging in practices that could harm competition, such as forming monopolies, fixing prices, or merging in ways that reduce consumer choice. By enforcing antitrust rules, governments protect both consumers and other businesses from unfair practices. This ensures that markets remain healthy, dynamic, and competitive, allowing innovation and fair pricing to thrive. Understanding antitrust is crucial for anyone interested in how modern economies work and how consumer interests are safeguarded. Fair competition is the backbone of a thriving economy. Without antitrust laws, powerful companies could dominate markets, set unfair prices, and limit choices for consumers. These regulations ensure that no single business can unfairly control a market, which encourages innovation and keeps prices reasonable. By preventing anti-competitive behavior, antitrust laws help small businesses grow and give consumers more options. This balance benefits everyone from entrepreneurs to everyday shoppers and keeps the economy vibrant and responsive to change. Several core concepts form the foundation of antitrust law. These include anti-competitive agreements, abuse of dominant position, merger control, cartelization, and price fixing. Each concept addresses a different way businesses might try to limit competition or harm consumers. For example, anti-competitive agreements can involve companies colluding to fix prices or divide markets, while abuse of dominance refers to a powerful company exploiting its position. Understanding these concepts helps clarify how antitrust laws work in practice. Anti-competitive agreements come in two main forms: horizontal and vertical. Horizontal agreements occur between competitors at the same level, like two manufacturers fixing prices. Vertical agreements happen between businesses at different stages, such as a supplier and retailer agreeing on resale prices. Both types can harm competition by limiting choices or keeping prices artificially high. Antitrust laws target these agreements to ensure that businesses compete fairly and consumers benefit from better products and prices. A company with a dominant market position holds significant power, but simply being dominant isn't illegal. The problem arises when that company abuses its power by charging unfair prices, limiting production, or blocking competitors from entering the market. Such behavior can stifle innovation and hurt consumers. Antitrust laws step in to prevent these abuses, ensuring that even the biggest players must compete fairly and cannot exploit their position to the detriment of others. Mergers and acquisitions can reshape entire industries. While some mergers create efficiencies and benefit consumers, others might reduce competition by creating giants that dominate the market. Antitrust authorities review large mergers to ensure they don't harm competition. If a merger is likely to create a monopoly or significantly reduce consumer choice, it can be blocked or require changes. This process keeps markets open and prevents the rise of unchecked corporate power. Cartelization occurs when competing firms secretly agree to fix prices, limit output, or rig bids. These cartels operate in the shadows, undermining competition and harming consumers by keeping prices high and choices limited. Antitrust laws treat cartelization as a serious offense because it strikes at the heart of market fairness. Detecting and breaking up cartels is a top priority for competition authorities worldwide, ensuring that markets remain open and competitive. Price fixing is a clear violation of antitrust laws. It happens when competitors agree to keep prices at a certain level, eliminating the natural competition that would otherwise benefit consumers. This practice can occur in any industry and often leads to higher prices and less innovation. Antitrust authorities actively investigate and penalize companies found guilty of price fixing, sending a strong message that such behavior will not be tolerated. Not every agreement or business practice is automatically illegal under antitrust law. The rule of reason means that authorities evaluate the actual or potential effects of a practice on competition before deciding if it's unlawful. This approach allows for flexibility, recognizing that some collaborations might benefit consumers or improve efficiency. By weighing both the positive and negative impacts, regulators ensure that only truly harmful practices are prohibited. The concept of antitrust gained major attention with the Sherman Antitrust Act of 1890 in the United States. This landmark law was created to combat business monopolies and restore competition. Over time, antitrust principles have spread globally, influencing how countries regulate markets. Today, these laws are more relevant than ever, as new industries and technologies continue to reshape the economic landscape. Antitrust laws are enforced by government agencies and courts around the world. These authorities investigate complaints, review mergers, and take action against companies that break the rules. In today's digital economy, enforcement has become even more complex, with cases involving large technology firms and global markets. Despite these challenges, the goal remains the same: to protect competition and ensure fair treatment for all market participants. India's Competition Act, 2002, reflects the philosophy of modern competition laws. It aims to foster competition and protect Indian markets from anti-competitive practices. The Act prohibits anti-competitive agreements, abuse of dominant position, and regulates mergers and acquisitions. Any agreement that causes or is likely to cause an appreciable adverse effect on competition is considered void. This law ensures that Indian consumers and businesses benefit from a fair and competitive marketplace. Under the Competition Act, anti-competitive agreements are classified as horizontal or vertical. Horizontal agreements are between businesses in the same industry, like two manufacturers. These often involve price fixing, market allocation, or bid rigging. Vertical agreements occur between businesses at different stages, such as suppliers and retailers, and can include exclusive supplier resale price maintenance. Both types are scrutinized to ensure they don't harm competition or consumer. Dominance in itself isn't illegal under Indian law, but abusing that dominance is. The Competition Act prohibits unfair pricing, limiting production, denying market access, and using dominance in one market to gain advantages in another. These rules ensure that powerful companies cannot exploit their position to the detriment of competitors or consumers. The law provides a framework for investigating and penalizing such abuses, maintaining a level playing field. A recent case involved the Competition Commission of India penalizing the Federation of Publishers and Booksellers Association in India, FPBAI, for anti-competitive practices. The FPBAI was found to have fixed conversion rates, set terms for pricing and credit, and issued lists of approved suppliers, all of which restricted competition. Despite previous warnings, similar issues persisted, leading to penalties and new directives for the FPBAI to spread awareness about competition law and withdraw anti-competitive advisories. This case highlights the ongoing importance of vigilant enforcement.